Welcome to another episode of Keeping Employment Law Simple. My name is Edward.
And I'm Emily.
And together we are the hosts of this channel. We'll be right back, so stay tuned. Today, we are going to talk about a selected case on discipline and grievance issues at work, providing a summary of the decision and implications for employers. The case in question is Can versus Stripe Star Limited, and the issue of the case is centered on appeal procedures.
Here are the facts. The claimant was a manager of a car workshop and he committed gross misconduct at work involving the unauthorised purchase of a customer's car and then carrying out repairs on the car in the customer's name without paying for them. The subsequent disciplinary hearing to address the misconduct only lasted 6 minutes. An employee had no chance to make representations. An independent manager was appointed to hear an appeal. He investigated thoroughly and interviewed all the witnesses. The employee was dismissed following the appeal and brought a claim for unfair dismissal.
Now, this is important, the decision. The Employment Appeal Tribunal said that the original 6-minute disciplinary hearing was unfair. However, the deficiencies in the first stage of the process were cured by the thorough and effective appeal. The appeal effectively provided the overall fairness that the law requires, and therefore the employee could not succeed with his unfair dismissal claim.
Implications for employers. Employers should always follow the organisation's disciplinary and grievance process and the provisions of the ACAS code. An employer may be justified in the summary dismissal, meaning a dismissal without notice, of an employee who has committed gross misconduct. But before proceeding, employers should still undertake a fair investigation and hearing. Even if an employee is guilty of gross misconduct, employers should follow a fair disciplinary process, and as part of a disciplinary process, employees should always be allowed an appeal.
Ideally, the person hearing the appeal should not have had prior involvement in the issues. If the employer has made a mistake in the earlier disciplinary process, it should always try to rectify the situation. A thorough appeal procedure may mean that a subsequent dismissal is fair and any deficiencies in the earlier dismissal procedures are rectified.
Employers should always aim to do things correctly at each stage, rather than rely on the appeal process to rectify any errors. However, a carefully handled appeal may enable an employer to defend an unfair dismissal claim.
If an employer loses an unfair dismissal claim because of defective procedure, it can still ask for any reward to be reduced because of the contributory fault of the employee. If the employer can show that a fairer procedure would have resulted in a justified dismissal, then the employer can seek what is known as a Porkie reduction to any compensation awarded. This reduction can be given on the basis that if the employer had got its procedures right, then the dismissal would have been fair. And that brings us, everyone, to the end of this video. Now, if you're looking for professional advice and guidance, you can contact us on
hubteam@hrhubplus.com
or 0333 577 0788. Don't forget to hit the subscribe button.